Section 14. Legal Hotline Q&A, Fair Housing Practice in the Market. Introduction. When clients ask you to break the law. As we continue into another Legal Hotline Q&A section, we are stepping into situations that agents face in real time, often with pressure from clients, HOAs, or landlords. These are the moments where your professionalism is tested. In 2026, knowing the law is not enough, you must be willing to stand your ground, even if it means walking away from a deal. Every scenario in this section highlights one key principle. You cannot participate in discrimination, even if your client asks you to. Let's break down these real-world situations and how you must respond as a compliant Arizona real estate professional. Scenario 1. Seller refuses to sell to non-U.S. citizens. A seller tells you they do not want to sell their home to anyone who is not a United States citizen. The question becomes, can you take the listing? The answer is no. Under federal law, specifically 42 U.S. Code Paragraph 3604, it is illegal to refuse to sell or negotiate for the sale of a property based on national origin. While citizenship itself is not always explicitly listed, it is closely tied to national origin and is treated as a protected category in this context. If you agree to represent the seller under these conditions, you are actively participating in discrimination. This exposes you to civil liability, disciplinary action, and potential loss of your license. The correct response is to decline the listing and clearly explain why the request violates fair housing laws. Scenario 2. FHEO poster. Only in English. A brokerage operates in an area where a large portion of the population speaks Spanish. The office displays the Fair Housing and Equal Opportunity (FHEO) poster, but only in English. Is this sufficient? No. Under Title VI of the Civil Rights Act of 1964, individuals must have meaningful access to programs that receive federal assistance. This includes individuals with limited English proficiency, LEP. If a significant portion of the community speaks Spanish, the brokerage should display the FHEO poster in both English and Spanish. Failing to do so could be considered a form of national origin discrimination. This is a great example of how compliance goes beyond minimum requirements. It requires awareness of your community and proactive action. Scenario 3. HOA pool. Restriction on children. An HOA has a rule that prohibits anyone under the age of 16 from using the community pool unless accompanied by an adult. A 13-year-old tenant is denied access because of this rule. Is this enforceable? Probably not. Fair housing laws protect families with children under the category of familial status. While safety rules are allowed, they must be reasonable. A blanket restriction preventing children from using a community amenity without an adult may be considered an unreasonable limitation. This could be viewed as discrimination against families with children. The key here is balance. Rules must be based on legitimate safety concerns and applied fairly, not used to limit access. Scenario 4. Tenant with a child relative. A tenant applies for an apartment and states that his 12-year-old nephew will be living with him. The landlord does not want to rent to anyone with children. Can the landlord deny the application? Probably not. Fair housing laws define familial status broadly. It includes not only parents but also individuals with legal custody or permission to care for a child under 18. The landlord may request documentation showing that the tenant has permission to house the child. However, if proper documentation is provided, refusing to rent based on the presence of the child would be a violation of fair housing law. This scenario reinforces that familial status protections extend beyond traditional parent-child relationships. Scenario 5. Service animal fees. A tenant with a service dog is charged a $75 HOA fee for DNA testing, which is required for all pets in the community. Is this allowed? No. Under fair housing law, service animals are not considered pets. They are classified as assistance animals and are protected under reasonable accommodation rules. Charging a fee for a service animal is considered discrimination because it places an additional burden on a person with a disability. The HOA must waive the fee and allow the service animal without additional charges. This is a critical point. Policies that apply to pets do not apply to service animals. Why these scenarios matter in 2026. Each of these situations highlights how quickly a normal transaction can become a fair housing violation. In many cases, the issue is not intentional discrimination. It is a lack of understanding or failure to apply the law correctly. As a real estate professional, your role is to refuse to participate in discriminatory practices, educate clients on fair housing laws, apply reasonable accommodations correctly, recognize when policies create unequal treatment. The best agents are not just deal makers, they are risk managers and compliance leaders. The golden rule: protect yourself and your client. If something feels questionable, it probably is. When in doubt, stop, evaluate, and seek guidance from your broker or legal counsel. Your license, your reputation, and your career depend on making the right decision, even when it's the hard one. Online discussion. Question 1. What should an agent do if a seller requests discriminatory conditions? Answer: decline the listing and explain that the request violates fair housing laws. Question 2. Why must FHEO posters sometimes be displayed in multiple languages? Answer: to ensure individuals with limited English proficiency have equal access to housing information and services. Question 3. Why are service animals treated differently from pets? Answer: because they are considered assistance animals and are protected under fair housing laws as a reasonable accommodation for disabilities.